Thank you. Please be seated. All right, Mr. Ratliff, I have some questions about your pleading. Are you willing to answer those?
Sure am.
All right. The pleading I'm looking at, it's not been entered in the case yet, and the pleading Give me just a second. All right. You did, in fact, file this electronically in CR. Well, that's wrong to the case number, but this is case CR 22-21-16-23, the state of Idaho versus Chad Daybell. Is that correct?
That's correct.
All right. I'll note the case number is wrong as well. You got it CR 12-21. The first part I want to know under Rule 11, which requires you to make representations to the court, you hold yourself out as, and title yourself attorney for the defendant. Why do you say that?
Judge, as you know, this is a template form, and I simply forgot to take that off of there. That was Scrivener's error on my behalf.
Okay, Scrivener's error. On the...
If you notice in the body of the motion, Judge, I say without permission of the defendant or his trial counsel.
All right, let's look at your signature on page 3. You signed Terry S. Ratliff of the firm, attorney for the defendant on page 3, don't you?
Again, because it was in my template.
All right, on page 2, again, a signature, Terry S. Ratliff of the firm, attorney for the defendant, correct?
I don't have a page 3, Judge. I just have a page 1 or 2.
Bottom of the certificate of service is one signature, another at the bottom of the contents of the pleading.
If it's there, Judge, it's there because it's a template form and I didn't strike it.
Okay, so 3 times you called yourself the attorney for the defendant. So who are you the attorney for?
Me.
So Terry S. Ratliff, attorney for Terry S. Ratliff in this case.
I should have signed citizen.
Citizen?
Yes.
Why are you referencing your bar number if you're just citizen?
Again, it's the form, Judge. It's a reference to the form. I'm not Mr. Daybell's attorney, never was.
You put this on a pleading. If you look at the top left, you've got your name, your Idaho State bar number, your Ratliff Law Offices, and attorney for defendant. You're telling me you mistakenly just wanted to file something as a citizen and not as a lawyer?
I was looking for immediate relief because of the concerns I had about the case, Your Honor.
And why were you doing that on a Friday night at almost midnight? You've known about this case for a long time, according to your own content here, right?
That's correct.
So why are you doing it then?
Because I thought I needed to do something to slow it down.
Trial scheduled for how many years? And you wanted to slow it down the day before trial started?
I'd also gotten calls from Mr. Pryor, Judge, for help.
That might be fine, but did he ever retain you on the case or did you ever enter an appearance for the defendant?
I did not.
All right, and you do state in here you're filing this pleading without the permission of the defendant or his counsel, correct?
That's correct.
You also state in here and call yourself an intervener. What basis do you have to intervene?
Based on my...
On the brief?
Yeah. It's set out in our brief, Judge, as to the basis for why I wanted to intervene. In the motion, I quote you the relief I wanted. I give you the grounds on page 1 as to why I wanted that relief and why I thought it was necessary.
Okay, and you're going to intervene now not as Terry Ratliff lawyer, Terry Ratliff citizen at large?
I think it's semantics, Your Honor.
Oh boy, let me stop you there. It's absolutely not. A bar licensed attorney filing something with their bar number to the court is completely different than a citizen. That is not semantics. This is what brings you within the auspices of Rule 11.
I understand. I said perhaps I should have signed it as a citizen, but I didn't.
All right. In your intent to intervene, whether it's as a citizen or an attorney, let me read you a couple of case quotes. Quote, "The Idaho rules of criminal procedure do not provide a process for intervention. The inability of non-parties to intervene in a criminal case recognizes that the considerations underlying intervention in civil cases are not applicable to criminal proceedings." That's People versus Ham, and that's State versus Johnson, 167 Idaho 454. And we've also got another Idaho case citing, quote, "Petitioners are correct that Idaho's rules of criminal procedure do not provide a specific mechanism for third parties to intervene in a criminal case." So again, I think there's settled case law that prohibits intervention in a criminal case. And I'd like to know what authority you have that says you have a right to intervene either as an attorney or a citizen in this case.
As outlined in our brief, Judge, sorry about that. As outlined in our brief, we have given the court several cases where the Idaho appellate courts have allowed people to intervene in cases in a criminal matter, even though they're not parties. That's my basis.
So you intervene, and then we've got two parties here. We've got the state, we've got Chad Daybell, and you're going to float around and be what if you intervene in this case? What are you going to be?
I'm not going to be floating around this case, Judge, because you haven't granted my motion.
Well, assuming you got to intervene, you assumed in your motion you did intervene because you called yourself the intervener once you got going in your motion. What were you going to be at that point?
I was hoping to have a hearing in front of you before the trial started.
Okay. And you said you were going to be the lawyer for the defendant or already were the lawyer for the defendant. Is that
not? I explained to you just a few minutes ago that that was a mistake.
Explain to me all of the misspellings and typographical errors in your late night filing.
I was nervous and it was late at night. I didn't take this lightly.
You didn't take it lightly, but you used the wrong form. You misrepresented if you were an attorney or a citizen, and you signed 3 times as attorney for defendant. And that's your explanation?
Yes.
All right. Mr. Ratliff, I find based on your responses, you have violated Idaho's Rule 11 under the Rules of Civil Procedure, which I find are incorporated through Idaho Criminal Rule 47 and 49. The court would note that in the rules under C1, it's mandatory. It says the court must impose an appropriate sanction on an attorney, law firm, or party that violated the rule. And similar to what would happen in a civil case with a frivolous type filing, which this was, this cost time, this cost effort, this cost real loss for the attorneys, for the court. I'm going to instruct counsel for both the state and the defense if they could itemize the time they have spent, both in today's hearing, in preparing for the hearing, as well as in dealing with this pleading from the time it was filed on Friday night, the 29th, whatever time you've put into that. I'm going to direct Mr. Ratliff that you pay reasonable attorney fees incurred for the time Mr. Pryor spent at his typical hourly rate, for the state's attorneys and whatever rate they are entitled to charge as public prosecutors. And the court will likewise itemize some billing time incurred in this. And the sanction the court's going to order is the payment of those attorney fees. The court will provide time for counsel to submit those. I'll review those for reasonableness before I make an order. And pursuant to the rule, which requires a written order under Rule C6 of Rule 11, the court will describe in that order the conduct and the basis for the sanction, and you're going to pay for those fees. Do you understand that, Mr. Ratliff?
That's fine, Judge.
Very well.
Your Honor, if I may, I'm going to request findings of fact and conclusions of law. As this court is aware, we submitted briefing that addressed many of the issues you addressed to Mr. Ratliff in great detail, giving multiple basis for his right to intervene. The judge, you have not addressed those arguments, and so I'm going to ask for findings of fact and conclusions of law.
All right. Well, Mr. Bartliff, you can ask. I'm not inclined to do that because, again, I've got a lawyer in front of me that submitted a pleading, and the lawyer is responsible for the pleading. I'm not necessarily allowing any further input on behalf of counsel for the lawyer that filed the pleading. I don't think it's proper because I'm not imposing any kind of jail time or sanction similar to Rule 75 of the civil rules, which would implicate on a contempt proceeding the right to counsel. So I'm going to stand by my ruling that I made and ask the attorneys to submit those. That concludes the matter for this afternoon.
Judge, if I may. I'm
You
sorry,
may,
Judge, I am
you may not. I'm done. I'm done with this issue, and I'm done wasting time on this issue in the middle of a capital case. We're done. We're in recess, period.